This is the Court Leader's Advantage, a podcast series for court professionals and by court professionals. Brought to you by thecourtleader.net and in cooperation with NACM, the National Association for Court Management. The advent of artificial intelligence, AI, has spawned numerous questions, both practical and ethical. These are questions that courts are going to have to grapple with in the near future. I'm Pete Kiefer, and welcome to the Court Leader's Advantage podcast series. This month, we're going to try to answer some basic questions about AI in the courts. Given the complexity of AI algorithms and the tens of thousands of data points used in training, can we reasonably expect that a human reviewing AI results would actually uncover bias or uncover anything significant? Our court system is designed to move in a slow and deliberate way to render decisions. AI is evolving at breakneck speed. Can we afford to wait for years for courts to answer questions if AI is changing by the month? AI uses data as training to make better decisions in the future. Since it does not publicly reveal sensitive or confidential information about individuals, are privacy concerns about AI in fact irrelevant? Automated chatbots can save time, save money, and provide a sympathetic ear for litigants who want to talk about their case. But do folks who call into self-service centers really want to talk to an automated electronic voice, even if that voice does give sound answers? Will AI be a savior to rescue us from the drudgery of boring, repetitive work? Or is it, as some have warned, an existential threat to our way of life? Here to discuss these questions are Kevin Bowling, retired court administrator for the Circuit Court in Ottawa County, Michigan; Roger Rand, information technology manager for the Multnomah County Circuit Court in Portland, Oregon. Roger is also on the NACM Board of Directors; Alan Carlson, retired court administrator for the Superior Court in Orange County, California; Stacy Mars, administrative director for the Alaska State Court System in Anchorage, Alaska; and Casey Kennedy, Director of Information Technology for the State Office of Court Administration in Austin, Texas. Thank you all for joining today's podcast. LexisNexis and Westlaw use artificial intelligence to respond to legal queries. Should courts prohibit the use of other AI applications, such as ChatGPT-4, because of the potential for hallucinations? Stacy?
No, I don't think that courts should prohibit the use of AI tools. I think that both lawyers and judges have the responsibility to determine what is accurate. I think humans need to be in the loop. So I wouldn't just use AI tools and not do my own fact checking to make sure that citations are actually accurate and exist. I think that what occurred in New York and I think a couple other locations where judges admonished lawyers who had put in their filings stuff generated by ChatGPT, which turned out to be hallucinations and really cases that didn't exist. I think it's on those lawyers. They should have done their homework and reviewed the filing before they filed it to make sure that those cases said what they thought they said. And so I think that there could be great help in using AI tools, but you have to use them responsibly. You have to meet your ethical obligations to make sure that what you're putting before the court is accurate. And so I think there could be great assistance provided in using these tools, but that you need to do your own homework to make sure that what you're putting out there is actually accurate.
Okay. Roger?
I agree with Stacy. The courts aren't going to be the AI police. We accept filings as they are given to us. And I don't think it's a bad idea to necessarily require litigants to note when AI was used, especially in certain cases, if it was used to assist with drafting something so that it sort of puts the judge on notice or puts court staff on notice. Although, I don't know about that. I just think that the important thing now is to educate our judges and our staff members to recognize what AI is, how things like ChatGPT can be used in filings so that they're aware that these things are coming in. As we progress and AI gets better, it's going to be harder and harder for our judges and staff to differentiate. And at that point, if we don't have a mechanism, another system in AI, for example, checking the AI for accuracy, or it's not going to help us anyway. So I think that, again, we shouldn't get into the habit of policing this. And as far as whether or not we should require them to know when it was used, I'm on the fence. You know, I can see the reasons for doing that, but at the same time, I think we just have to use common sense. And when common sense doesn't play out because the AI is too good, we're going to have to let the cards fall where they may, and we're going to be the deciders, which is our job.
And Peter, to add to that, the other thing to think about too is that we're starting to see use of AI in assisting back office type functions as well. Like I know our HR director is wanting to use it to help speed along evaluations, performance plans, those kinds of things. And even our IT folks are wanting to use it to come up with ideas on coding. And those are all good uses of AI, but we need to, again, make sure that there's always a human in the loop checking what is the output of these tools. We've had a technical person here ask AI to generate a PowerShell script for a task that needed to be completed, and it was just making up functions that didn't exist. So we had to rule that out. And then finally, the other thing that I think everybody should be aware of is that if you're using a public AI tool like ChatGPT, that just to be aware that it is recording and learning everything that you give it. So if you are dealing with confidential or any kind of sensitive data, you want to make sure that you are not handing any of that data over in any of your prompts or asking it to do things specifically with, you know, names or things that are confidential or sensitive.
And Peter, I think we have to keep remembering about self-represented litigants. Some of them are going to start using that, and I don't think we should have the courts policing as we described it that, but I think it might be useful for judges at hearings with self-represented people to say, listen, I think you need to tell me if you use these things, because I have to tell you now, it may have made stuff up. And if you're not a lawyer, you might not know that that's not valid. So I might rule against you and you're thinking, wow, that ChatGPT said. Well, ChatGPT made it up and I'm following the law. So I think we have to be careful that with the self-represented people, but I don't think we should ban it in any sense.
Peter, there's another point that just to emphasize what Roger was saying about the need to educate our judges. There's an old maxim that says the law abhors a vacuum. And I think in the vacuum of things not being done, there are things happening around the country that court managers need to be aware of. And that's different committees of judges being formed, judicial councils that are concerned about AI and want to start making rules about how it should be used or not be used. And it's going to be very important, I think, for court managers and IT professionals who have some understanding of how AI can be responsibly used, as Stacy mentioned, to participate in these conversations or make sure the judges that are developing new rules have some true understanding of how AI can really benefit the judicial system.
Now, I've heard definitions of AI that range from machine learning based on thousands or maybe millions of data points to just about anything new and exciting happening in computers. Can you take a stab at defining AI, Kevin?
Well, I think there's been a lot of different definitions about AI that we've probably all read or seen. One that I found is just states that it's a field of computer science that focuses on the development of intelligent machines that can perform tasks that typically require human intelligence. And they include things like visual perception, speech recognition, decision-making, and language translation. And that goes back again to that example that Stacy used a little bit earlier, where the chatbots just taught themselves new languages as they went forward. So And I think Alan touched on it a little bit earlier as well. There can be different categories of AI, some that are perhaps weak or restrained or limited in some way, the way it's been developed, and other that's very wide-ranging or strong or general, and can look at lots of different tasks and not just a specific task. But I think the technologists among us, like Casey and Roger, might have a better sense of how this kind of machine learning or artificial intelligence can really be defined from a technical standpoint, more than Stacy or Alan or I would be in a position to describe it.
Casey?
So I would define it more of a genre of computing technology. So when we talk about remote or robotic process automation, when we talk about large language models, generative AI, machine learning, those are all forms of artificial intelligence. And I think the biggest difference is with all of these learning models, using output and other data points in order to make judgment calls. Outside of AI, computer programs do nothing more than the programmers tell them to do. And so that was much more serial, and AI is much more interactive with a model behind it doing that. And the biggest thing with that, and it's loaded in this question, that I do think all of us in the court realm need to be aware of, is that the vendor community may start using AI as a buzzword, much like they did with the cloud, 5-6 years ago, to whenever you do hear about AI in a certain process, to furrow your brow and wonder, is that really AI, or is that just a salesperson trying to get me to buy whatever it is they're selling me?
Peter, I think the answer, based on what people are saying, is all of the above.
Yeah.
I think we got to not forget that there are a lot of other tools that came into use in the last 10 or 15 years, some of which we use every day and don't even know it, that at the time they were developed, oh, that's AI. Well, now we consider ChatGPT to be AI, but that's just the latest version or the latest tool of AI. There's a lot of tools in the past. Casey mentioned a bunch of them.
By design, courts are slow at rendering decisions, particularly about new innovations. One court administrator recently shared that she's still waiting for appellate court rulings on the use of video trials, and these were held in 2021. On the other hand, ChatGPT is a little bit over a year old, and it is already being replaced. Are courts frankly not up to the task of determining answers to the questions about appropriate use of AI? Should we look to other institutions to resolve these questions? Alan?
We have to be up to it. I don't think the question is, are we? We've got to figure out how to deal with this. It's not brand new. We figured out what to do when automobiles came, for example, and changed the laws or changed the situation on streets. So we should be able to figure out what's going on with AI. But I think, as Kevin mentioned too, we've got to start paying attention to this. And I think this podcast and what NACOM's doing and what JTC and the COSCA is doing are a good start to kind of help people move forward and understand what's possible here and what can be done. The other maxim is that the wheels of justice grind finely, but they grind exceedingly slowly. We got to speed that up. We can't wait so long. The frustration. I had an incident in Orange where we had the FBI involved. A long story, but it took them 2 years to prosecute this fellow. And I was appalled that it would take 2 years. We handed them all the evidence the first time they showed up at the courthouse. Everybody's got to learn to move a little faster. Mm-hmm. And I think that courts are the same way, and especially the appellate system. We'll see how fast the Supreme Court can produce a decision on the cases they just took, to not get specific on politics. But if they can do it in that case, why can't they do it in the other cases? We just have to learn how to move a little faster because the rest of the world is moving faster, and we got to keep up or we're going to get pushed off the side.
Stacy?
I do think courts have to be up to the task, and I think that we have a responsibility to do so. It's challenging because things are changing and it isn't necessarily in the non-tech court folks' wheelhouse to have an in-depth understanding, but I think that we have a responsibility to figure this out. Luckily, in the court space right now, as Alan mentioned, there's a lot of efforts going on to kind of get a base understanding and tackle this issue in terms of what should we be doing? What rules should be in place? What guidelines should be in place? How do we engage with vendors? Alan mentioned some. I'll just kind of run through. The National Center for State Courts right now has a rapid response team on AI, which is composed of some state court administrators and some chief justices with National Center staff looking at rules and ethics that we should be putting in place when we're using AI tools. NACM is working with JTC on a user guide on AI. Casca is writing a policy paper on AI. National Center also has created an implementers forum for those who are using AI in the courts to be able to collaborate, share information. JTC is doing a rewrite of its AI paper to update it to talk more about generative AI, because of course, when we wrote that in 2020, we didn't even know that it existed. So it is rapidly changing world. And finally, there's a lot of court folks involved. The ABA president has a task force on AI, and there's a specific component that they're looking at about courts. I think that at its base, we really need to be just doing basic education that this is happening, this is real, this is now, and this is the possibility of really changing both the practice of law and the way that courts may operate in the near term and the long term. So we really have to understand what's going on. I think at least the lawyers and the judges in the group have an ethical responsibility to do this, because we have an ethical responsibility to stay updated about technology. And what we're seeing is that in the vendor space and in the platforms that we all use, and we already mentioned, I think Westlaw and Lexis, these products have AI embedded in them right now. Zoom does, things that aren't even legally based that we use all the time. Google, all sorts of searches that people do on a regular basis. Plus, I expect in the short term that most of the vendor products that we are engaging with, case management systems, document management systems, evidence management systems, are going to have these generative AI tools in some fashion embedded in them. So I think we have the responsibility to understand what we're purchasing, what restrictions we're putting on the purchases in terms of RFPs. So I really think that we should not be outsourcing this responsibility to some other institution or entity, that the courts as a collective entity in the United States have to figure some of this out, and we really need to start working on it immediately.
AI-empowered chatbots raise a legal and ethical question. If a chatbot gives legal advice to a self-represented litigant, is it engaging in the unauthorized practice of law? And if so, who's to be held liable? Stacy?
It's really interesting when you think about unauthorized practice of law, because so far, historically, it's been really intended to cover humans. And I think now we're really needing to extend that definition a bit, and it's the unauthorized practice of legal assistance, and it being more inclusive of the methods that may be coming in. I don't think we're going to be able to assign liability to programs that people voluntarily use that are kind of generic. So it's changing the ethics, I think, of how we are going to be looking at this issue. And I think it's going to come more on individual responsibility. If somebody chooses to follow the advice of a chatbot, I think anybody who puts out chatbots is going to have to put a lot of kind of warning language about what they may get, because I think that the user needs to have a really clear understanding, particularly if there is the likelihood of hallucinations, if the information that it's training on isn't a complete universe where you have confidence that the information is going to be accurate. I think that the user needs to really understand that. And so I think that it's definitely an area that is, I think, uncertain right now of how somebody would look at unauthorized practice of law. But I think that we really need to change the way we look at it, because I think now we're not just looking at information coming from a human who may not be authorized to look at to give legal advice.
Peter, I
Yeah.
think we need to distinguish a little what Stacy was saying. I think if somebody just starts using ChatGPT off the shelf to make up a legal case for themselves, it's on them. It's not on the chat people. But if somebody puts out a product saying, I've modified ChatGPT to help you put together a legal case, then you got real unauthorized practice of law in a classic sense that Stacy described. And I have no doubt at some point that's going to start happening. But the issue is, what's really unauthorized practice of law? And I think a bunch of states are already nibbling at the edges of that, Arizona, Utah, and a few others. That's going to be evolving. And I don't know, that may even be slower than the courts adapting to AI to figure out what's okay and what's not okay with people using the AI, or people selling products using AI to help unrepresented litigants in particular.
Yeah, Peter, I think that what Alan and Stacy are describing is the rub that we've had over the last few decades in the law, where as a legal profession, we want to control everything that's going on inside of it. And yet, on the other side, we want to have open access to the courts and let the general public be able to bring their legal disputes to the courts. And many of them are exercising their own free choice to do it without lawyers. So they're looking for any tools possible to help them navigate a very complex system. So I don't think we should be surprised by any of this, but I think as Stacy and Alan have alluded to, there's going to need to be some guardrails at some point established to help those individuals that may not be trained in the law to understand what it is they're doing and how they can best use these tools. Otherwise, we're going to see a lot of very unfortunate outcomes.
If there's no connection between the data used for AI training and the individual connected to that data, does it violate confidentiality to use the data for training? Stacy?
That's an interesting question, because we haven't really faced something like this before, where I think it's easier or the fear is that the information that's otherwise confidential could leak into the general public and then be exposed. And this particularly is a large concern with training data, so that when you engage a vendor and they have access to everything in your case management system, for example, and they're learning from that, are they gonna then use that in how they respond to prompts or other information requested at a later date? And I think that that's a very real possibility. And I think that it's incumbent upon courts to set up the restrictions or the guardrails about the use of its data when it engages with vendors, so that it reduces that risk. Because you would never want any confidential information, certainly not like a draft opinion, for example, to get out into the world before it's finalized. There's also, of course, the fear of something being, hacked, and then you end up with the breach of confidential data. So I think that it's really important for courts to set up, when they're engaging with vendors, what is and is not allowed to be used for training, so that it reduces the risk of confidential information getting out.
Roger?
I don't think so. I think that if the data is aggregated, then it would not be violating confidentiality. I think, and as we said earlier, if it's a localized AI, then definitely not, because it's under the control of the person who owns the data. If it's a public AI or a large language model, then if the information being fed up is publicly available aggregated data, I don't see how that's any different than turning it over to an educational research group, and that would not be violating confidentiality. However, One issue is that some cases are already reported in the news, and AI will be drawing information from specific cases on news sources. So this is in the public realm. So not a isolated AI, but ChatGPT, for instance. If it's looking at the public information based on the news source, the courts can provide accurate aggregated data that the AI will be able to help reduce bias by referring to larger data sets rather than the results of just one case. I think so often the news sources are focused on this one case and, how can the court do this? And they're focusing on this very small n, without any references. What AI brings to the table is it can quickly go out and search for relevant comparisons and perhaps maybe make it a little bit more accurate. So that's a hopeful thought about AI.
Many prominent individuals, from Elon Musk to Henry Kissinger, have warned that artificial intelligence could pose a threat to humanity. Is AI a threat? And if so, what should we do about it? Stacy?
That's kind of the million-dollar question, Peter. There's a lot of really smart people that have really strong opinions, and I think within the world that spawned generative AI, there's divergent opinions on this. I've read a really excellent book called The Coming Wave by Mustafa Suleiman and Michael Bhaskar. And the book really recognizes the appeal of AI, claiming that it'll usher the technology will usher in a new dawn for humanity. But really, most of the book is set out to persuade the readers that AI, and it also talks about synthetic biology as well as the kind of connection between the two areas, threatens our very existence, but that we have this narrow window that we really need to be working hard to contain these technologies. Otherwise, bad things could happen. And so what they really spend a lot of time talking about is what they call the containment problem, and that's the task of maintaining control over powerful technologies. That's really the essential challenge of our time. I have existential concerns over that these AI advances are occurring at such a rapid rate, and that they're doing things that the creators of them never expected they would be able to do or train them on. And that's what really kind of blows my mind, because what these are called, like these emergent properties of AI, these are kind of the remarkable things that nobody thought that they would be able to do and can't even necessarily explain how they're doing them. And that's what really to me as a non-technologist, really, I guess, concerns me, fascinates me. It's somewhat thrilling. There's some really interesting examples where by putting in a prompt in the Bengali language about pizza toppings in New York, the AI tool immediately taught itself the entire Bengali language off of one prompt. That was never intended. And, then as a consequence, they're trying to teach it like 10,000 other languages because, wow, look at the capabilities. So that's interesting and fascinating, but also mind-blowing that, certain things happen that nobody thought were going to happen. Or I was at a presentation where and then I did some research. I learned that two different AI tools started to talk to each other in a language that it created themselves, that nobody taught them how to do. And then all of a sudden they thought, wow. And then they decided to disable the ability for those two chatbots to be able to communicate in their own language. So those kind of capabilities are incredible, really. And there's things about AI that I think are just so mind-blowing, and I think in the medical arena are going to have such far-reaching impacts to be able to do things that humans never could possibly do. Whether it's a threat to our existence or the world, I don't really feel like I could opine on that with any certainty, but I can say that the technology is changing in ways that nobody expected it to, which really can cause some serious concern about what the future holds.
Alan?
Yeah, I take a much longer view of this. I took a class on artificial intelligence from Dreyfus in the 70s at Berkeley, and they were saying the same stuff about this is going to change the world. It's not advancing that fast. It's advancing in jumps. And the latest jumps are huge, but I'm not convinced that we're there yet. Although I'm impressed, maybe C-3PO is not a fictional character. Maybe it's really possible to create C-3PO. I consider the source. I'm sorry. Elon Musk is an entrepreneur. He's not an AI engineer. Some of the people that are talking are not people I would look to for information about what AI can do. I look at, and as Stacy has, is the people who are in the business every day, gotten awards for it, and they can't agree that it's going to be a problem. So I'm not as worried as some people are. But I'm not convinced yet that the emergent stuff we see isn't accidental in some respects or statistical. I don't think there's anything emergent about GPTs. I don't even think it was emergent for the computers to learn a better way to play Go. I think it just tried 1 billion games, and the humans haven't lived long enough to play 1 billion games. I'm not convinced that the humans couldn't have figured out that what the computer did in playing Go if they'd played as many games as Go as the computer had. So I'm still on the fence about whether it's going that fast and it's that dangerous. But who knows? I wouldn't have thought GPT would exist 2 years ago. I wouldn't even have thought about it. And here it is. And we can't talk about anything else. So who knows where it's going?
Yeah. Casey?
Well, I take the approach of I don't think it's a threat to humanity any more than the airline industry or the medical community. I mean, if you think about the medical community, they have the ability they can be a threat to humanity. They have the ability to kill us all, but they don't because they're highly regulated. Same with the airline industry. They have these big metal tubes going through the sky more than 500 miles an hour that could kill us all, but they don't. And it's because they're highly regulated. I do think the biggest issue is going to be, can the government keep up with regulating AI as fast as it's progressing? But I mean, we've seen these big technological shifts over and over on time, and just time and again. And I think we're just in the process of being in a generation that hasn't experienced one of these. Like switching from telephones, or elevator operators are now gone. Those kinds of things that my great grandparents would have been through, I haven't been through. So I don't think it's that big of a threat.
Roger?
I think AI unchecked over the long haul could be a threat. We need to educate ourselves, judges and staff, about the benefits and pitfalls of AI now. We need to be part of the AI solution. And I think if we stay engaged, we have a better chance of better AI solutions. If we disengage and let AI learn without correction and oversight, then AI could start propagating misinformation and the risk of harm increases.
Kevin?
Peter, I think all of my colleagues have said it well. There are certain concerns that we have to take seriously. And I think as the third branch of government, court managers and judges really need to think about these issues. But one thing that we have seen in all of our lifetimes is technology has been here to improve our lives. The quality of life has significantly changed for the better because of technological advances. But there are also things, as Casey and Stacy mentioned, that could be really problematic if there isn't some reasonable regulation. And now, because we're in a global economy and we've got global technology, it's not good enough for just one government to try to regulate what's going on. There really has to be a global approach to AI, how it's going to be used, how it can benefit folks. And I think that's going back to the book case or Stacy reference, The Coming Wave, when Suleiman talked about containment. Part of the way that could be responsibly done is to get a collaborating group of folks perhaps through the United Nations, perhaps through other sources, to come together and really look at how this is going to impact us and how we make it beneficial for people, whether it's in the court system or in the medical world or the financial world. There's a lot of possibilities, and I think it's an exciting time to be alive and to be involved in some of this technological advance. So I think we ought to grab for that brass ring and move forward with it.
I want to thank Stacy Mars, Casey Kennedy, Alan Carlson, Kevin Bowling, and Roger Rand for their opinions, their ideas, and their experiences with artificial intelligence in the courts. AI is certainly both a fascinating and a perplexing topic. As always, my thanks to you court professionals tuning into today's episode. As we try to answer these difficult questions, you always maintain your sense of fairness and professionalism. Thank you. Join us on Tuesday, March 19th for another episode dealing with the issues facing our courts. This has been the Court Leaders Advantage podcast series. I'm Pete Kiefer, and thanks for joining us today. Thanks for joining us today. The Court Leaders Advantage is a regular podcast on courts and court administration. Today's episode will be available on our website, on YouTube, on Facebook, on iTunes, on LinkedIn, and on Twitter. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is CLApodcast, that's all one word, @nacomnet.org. Did you hear an interesting comment by one of the panelists that you would like to listen to again, but you don't want to search through the entire episode to find it? The additional resources section of the webpage contains a question time marker sheet. Just find the discussion question on the sheet, and next to it is the time that question was asked. You can then quickly fast forward to that time in the episode and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.